Hi, my name is Jim Loftis, and I'm here today with my good friend, Mike Denger. Mike, why don't we get started by having you describe how you got interested in antitrust law?
Well, Jim, it actually began with an interest in economics. Like Bob Joseph and Joe England and Don Clawwitter and a host of others in the section, I was a high school and college debater. And a lot of economic subjects were debate topics. So I had a keen interest in economics when I took a number of economics courses then in college. And one of those was a course on antitrust law that looked at the legislative statutes and the judicial developments from an economics perspective. And that kindled my interest, and then I was fortunate enough to have a small section in my second year of law school taught by a young assistant professor by the name of Steve Breyer. And the course was just fascinating, and as I recall, Joel Klein and Doug Melamed and Bruce Wasserstein and a host of others who in one way or another were involved with antitrust law also were attendees in that class. And that led to my taking my senior paper with Don Turner, who had just returned to Harvard after being Assistant Attorney General in charge of the Antitrust Division. And then after a short stint in the Army, when I returned to my law firm, I was lucky enough to come about 10 days before the FTC filed their soft drink cases challenging exclusive territories by Coke, Pepsi, and others in the soft drink industry. That case was absolutely fascinating, and after that, for the next 40 years, the great majority of my time was spent in antitrust.
Well, thinking about today, is antitrust law something that you would recommend young lawyers get into?
It is. It was a little different when we got involved. The firms were smaller. The practice was not as national or international in scope as it is today, but I think the features that made antitrust attractive, at least to me, are still largely present. And they would include just simply the fact that antitrust is very fact-specific. I could not have lasted 40 years as a lawyer drafting corporate agreements, I can tell you that right here and now. But each case was different. There were all sorts of economic issues that were intertwined with the antitrust issues. I found that fascinating. The quality of the antitrust bar, I think, is very high. It's fun to practice with and against many of my colleagues in this area. And then antitrust itself, it's now global with international practice before tribunals in many countries. And also it's criminal, it's civil, it's class action, it's counseling. There's just a whole host of things. So all of those things that came together that made antitrust fascinating for me, I think, are still largely present today.
Well, how did you get involved with the antitrust section of the American Bar?
Well, actually, that's an interesting story. As a young third-year associate, I was working for a partner who was chairman of the Sherman Act Committee. And he had enlisted me to prepare first drafts of Sherman Act Section 1 and Section 2 chapters.
You volunteered?
I sort of volunteered, but actually it turned out to be a worthwhile assignment because he and I were also involved in an antitrust case. And there was a meeting scheduled where I actually first met you, a midwinter meeting of the antitrust section in St. Martin's. And allegedly the purpose of the drafters going was to work with the editorial board to put antitrust law developments in final shape. Lo and behold, the courts, as courts are known to do, scheduled a hearing during the midwinter meeting. And it was on some relatively inconsequential motion, but the partner decided to go to the hearing and send me off to St. Martin. So that's how I got involved in the antitrust section, attending a meeting at St. Martin where I met you and Irv and Harvey and lots of other people. But I'm hard-pressed to remember how much work we actually did editing those chapters.
I remember that meeting well. I think we both got sunburned, as I recall.
That we did, and it was a fascinating trip. There's one interesting thing happened at that meeting, and my wife and I didn't have two nickels to rub together, and we went down there, and a number of the people there were buying duty-free liquor to take home. And we thought that, this has been our first trip out of the country. We would go do the same. And we went to this store, and we were going to get something exotic, like, at least for us at the time, anything other than beer was pretty exotic. So we were going to buy some cognac, and there was this wonderful box, and it was labeled well, and the price was attractive, and it was called Cognac au Pruneau. And we bought this, and we took it home, and we opened it up, and we found that Cognac au Pruneau, had we read French, means prunes in cognac. So it was...
so that's how you learn French.
That's how I learned, at least, au Pruneau is not something you want.
Well, is the antitrust section something you would recommend to young lawyers?
It is, and pretty much for the same reasons that I enunciated why antitrust is attractive. But also over the years, the antitrust section is a meritocracy, and it's a great place to learn. The programs and the publications are, I think, absolutely first rate. And at the same time, you can advance because there are lots of opportunities. And over the years of watching the section, it's been my experience that people that work hard and do a good job move up through the ranks, and you get to meet a lot of people. And particularly, you get to meet people from the government or from corporations. Or if you're a plaintiff's lawyer normally, you get to meet defense counsel and vice versa. And you get to meet them in a non-adversarial setting. And I've just always found that that's was one of the best things of the section.
Well, you were chair of the section from 1992 to 1993, but your involvement obviously predated that by quite a bit and continued long thereafter. What have you seen that you would think are some of the most significant accomplishments of the section?
Well, I think in general terms, it's the P&P. It's not pickle and pimento loaf, it's programs and publications. And I think for 30 years, those have been the mainstays of the section's activities. And it's kept the section in good financial health, and it's contributed a lot to the education of the bar. And things like antitrust law developments, which you and I were involved on, and which is now in its 6th edition, I believe, has just been a fantastic resource to everybody that practices in the field and to the courts and to the government enforcement agencies as well.
You must have had some memorable experiences during those years. Describe the ones that come first to mind.
Well, in the antitrust section, we used to meet regularly to work on the text of antitrust law developments. This was like 1982 to 1983. And your wife, kind soul that she was, used to bring us boxes of donuts. And we soon found we were consuming large amounts of donuts during these working sections. So we started cutting the donuts up, and first we cut them into halves, and then we cut them into quarters, and somehow that was going to save us from our sins. But we found out even when we cut them into quarters, we still ate them all. We just ate them only 1/4 at a time. And the developments project was just absolutely fantastic in terms of developing a wide-ranging knowledge of antitrust law.
Other memorable experiences?
In the antitrust section or otherwise?
The full range.
All right. I guess the most memorable experience I had was actually in a case, and it was in the consumer bags case, which was the first felony trial under the antitrust laws, after antitrust violations became a felony instead of a misdemeanor. And there was a young lawyer for the government by the name of Dunn. And in this trial, the trial was about consumer bags, but there were bags that were slightly, maybe more than slightly, but larger bags that were called multi-wall bags. And in the consumer trial, the immunity was limited, obviously, to consumer bags, but the lead government lawyer asked the CEO of our company, who was an immunized witness, a question about potential price fixing, should we say, on multi-wall bags. There never was an indictment. But in any event, the witness looked at me, realizing that it was not the subject of the trial, and I was sitting in the back of the courtroom, and I got up and instructed an immunized witness not to answer a question. And Judge Bechtel went like this with the handcuffs. And he said, "Mr. Denger, this better be good." And I had just had a case in the Third Circuit where this was pending. This was in Philadelphia, where I could argue about variances from the indictment and how we were trying to protect the trial itself and so forth. But the lead government lawyer got up and said I didn't know what I was talking about, and the bags he was asking about were in fact consumer bags. Whereas then Don Clawwetter, bless his heart, because I still might not be here today if it wasn't for Don, even though it was a first-year government lawyer, got up and said that his senior did not know what he was talking about and that I was right and that these were not consumer bags. So the moral of the story is I didn't go to jail, and I'm forever indebted to Don.
Well, you both survived a
Yeah.
brave moment.
Yeah, there have been lots of great stories that happen in litigation over the years. Joe Alioto Jr., who was just interviewed, I can remember a case involving his father. And unlike most of the cases he was involved in, which were jury trials, this was a preliminary injunction hearing in a merger in the district court in Delaware. And a wonderful judge, Chief Judge Latcham, was presiding. And he had just gotten the final papers at 6:30 a.m. that morning, and the hearing was at 10 o'clock. And when it came for Joe to argue, the jury box was filled with ARB lawyers, and there were everybody over there, and it was sort of big trial. Maybe it had some of the feeling of a jury trial, but Joe turned to the ARB lawyers in the jury box, and he was making his case passionately to them. And then Chief Judge Latcham said, "Mr. Alioto, I thought you should be aware I'm the only one with a vote in this courtroom." And it brought down the House.
The arbitrageurs had no vote.
The arbitrageurs had no vote, at least as to this decision.
But Joe was going to play to them.
Absolutely. But we've just had, tons of fascinating experiences over the years. In a criminal trial in Dallas, Texas, it's the only time I've ever been aware that you can suspend a trial in mid-afternoon so that the judge and jury can go out and watch the Dallas Cowboys in a parade after they had won the Super Bowl. But I mean, all sorts of
Priorities.
happen over the years.
Yes, indeed. Well, tell us a little about some of the significant matters, not just memorable, but significant matters you were involved in.
Well, some of the most significant ones were, I guess, starting out off of an ABA project, which was the second monograph of the section called Vertical Restrictions Limiting Intra-Brand Competition. And this was one of the early monographs, and monographs, as you know, having done some, are supposed to be a dispassionate statement of the law. And we wrote this monograph fortuitously just as the Sylvania decision was coming to the Supreme Court. And the American Bar Association lodged the monograph with both sides and with the court. And the monograph was cited 6 times in the Supreme Court decision, favorably, I might add, by both the dissent and the majority opinion. We had a little something for everybody. But working on an issue that was that timely was memorable for me. Another case, again, one that you were involved that I worked on, was a pro bono antitrust case. Not too many people get a chance in their careers to do a pro bono antitrust case.
I was a witness, as I
You were a
recall.
witness, as was Jim Rill and several others. This involved the Superior Court Trial Lawyers Association, the lawyers that represent indigents accused of crime in the District of Columbia, and they were being paid the princely sum of $15 an hour for out-of-court time, $25 for in-court time, $1,000 maximum for felonies and $400 for misdemeanors, and hadn't had a raise in 10 years. Well, everybody and everybody's cousin, from the U.S. attorneys to the Judicial Conference to every organization said that these lawyers deserve a raise. And they went on strike after announcing several weeks in advance that they could do so. And the Public Defender Service, which are paid government employees, basically handled or stopped taking cases so they could handle them during the strike. And as you know, the prior strike in the 1970s went on for months with the, quote, uptown bar coming down to handle the cases while the SCLTA lawyers were on strike. But they settled it. They were invited by the mayor and by the city council and by the courts to a cocktail party after the government decided that they would raise their rates to $35 an hour. Everything was fine until the FTC sued them for engaging in an unlawful boycott. So I was lucky enough to lead the defense with Will Tom and Willis Snell and others, and we called you and all of the other lawyers who had handled cases in the prior strike to establish that they didn't have any market power, and this was a symbolic strike, perfectly consistent with freedoms recognized under the First Amendment. And we won at the trial level, and as happens in these cases, we lost at the commission level. And then we won in the D.C. Circuit with an opinion by Judge Ginsburg that said basically the test should be market power. If they don't have market power, then it's more symbolic speech rather than coercive behavior on the courts. But then the case was ultimately lost in the Supreme Court, as you know. But at least in my judgment, Judge Ginsburg had the right approach that if there was symbolic speech here, which there clearly was, it's not made unlawful unless there is market power where you can coerce the government into behavior that the government didn't want to engage in.
Yeah.
That was a fun one. Then we had Legion in the Supreme Court, where we overturned a per se rule of Dr. Miles that had been in effect since 1911. The Epigram case in the Supreme Court. But one of my favorites was a case that you were involved in as well, involving Independence Air, then known as Atlantic Coast Airways. And Atlantic Coast Airways was a United Express carrier. They had basically were in a difficult situation because United was in bankruptcy court. They wanted to get out of their United contract. They wanted to compete as an independent airline out of Dulles, flying several hundred flights a day. And we ended up suing another United Express carrier named Mesa Airlines, who had proposed to come in with a proxy solicitation to change our board to prevent us from becoming an independent airline. And they also made an exchange offer. And after a 2-day trial, we managed to enjoin an attempt to take over a board on Sherman Act Section 1 grounds. And also on Sherman Act Section 1 grounds, we enjoined a private takeover attempt, the first time that had been done in 25 years. And that was an absolutely fun case, and I thought it, at least for several years, produced concrete benefits to citizens in the Washington area.
Yeah.
A plug for the D.C. Corporation Counsel and the Virginia Attorney General, who also lodged papers in the case saying that this was a serious issue that they needed time to investigate.
Yeah, that's a good example of a case where I know you were told it's hopeless. There's nothing you can do here. All of the precedent is on the other side.
It was. We did not proceed, even though it was a takeover case, under Section 7, but proceeded under Section 1 with a very simple conspiracy theory that Mesa was working in conjunction with United to suppress competition from this potential new independent airline. Yeah. So we kept it simple, stupid, as they remind us from time to time in the Army, the old keep it simple principle, KISS principle, and it worked.
Well, talk, Mike, a little about your thoughts on public enforcement. That's something that has changed so dramatically from time to time. since you and I began practice. What are your thoughts today on that?
Well, if you look at the courts and you look at the enforcement agencies, I think we've moved in the right direction. Economic analysis is now much more heavily rooted in antitrust policy. And if you look at the courts, they've backed away from the per se rules, or they've substantially narrowed them in all sorts of vertical restraints and elsewhere. Market definition has become much, much more reasonable. The one area, if I had to pick out one that I would be concerned with, is Section 2 enforcement, particularly in the days of rapid innovation, global markets, very fast product advances. And if you look at all the time and resources that they consume, and you look back over the last 20 years of the results from the Section 2 cases, I would have substantial doubts about the wisdom of concentrating a lot of resources there. I guess if we do have a moment, Jim, there's a couple things I'd like to talk about that you and I worked together on in the section.
Of course.
And that I think have had lasting benefits. One is the annual developments volume. And as some of you who are old enough may recall, the Antitrust Law Developments Board used to do a supplement, which would come out on some sort of irregular schedule, typically not timely, where the thrust of it would be the text would say, add to this sentence to this third paragraph on page 2, or delete this footnote. It was really not very useful, and we came out with an idea to keep it at freestanding volume that would parallel the organization of antitrust law developments, but that would be a separate freestanding text, and that we would try to get it out each year by the time of the spring meeting so that it was timely. 19 years after you let me persuade you to be the editor of the first annual developments volume, that project is still going. And the sidelight is it generates substantial current income for the section each year to help our revenue flow. The other one is a project that I'm particularly proud of that Kai Ewing and I got off the ground, which was the State Antitrust Practice and Statutes volume. And there was no good state-by-state resource available at the time. And with a lot of the help from the state attorneys general, who reviewed each chapter and who contributed a lot to the drafting, we came up with a 3-volume state-by-state treatise where each chapter was organized in the same format for each state, and the statutes were included, and it was a readily available concentration of material. That, I think, filled a void, and we're now in our, I think, 4th edition of that treatise, and that also has had some staying power. And those are two of the things that I'm particularly proud of that we got off the ground during the time that I was very active in the section.
You were telling me a story earlier about the beer wars, which I found fascinating because of the uniqueness of the way the record was created and transmitted. Could you tell us a little about that?
Well, I'm not entirely sure which of the many beer stories you're talking about, but one of the beer war stories was we had certain assets that were in play. And this was right after the Herfindahl-Hirschman Index was put into the government guidelines. And depending upon how you divided the market, because there were geographic markets, you could have an effect where an acquisition would actually lower the market shares if part of the company's sales were in one geographic market but not another, depending upon where the other companies were. So the trick was each side was trying to, maybe I could use a word from American politics, gerrymander the markets a little bit so that under the Herfindahl Index approach, they passed muster. And I don't know if that's the one you were thinking about.
I was thinking of that, and also the one where you had 2 identical records going to 2 different courts
That
of appeals.
was in the soft drink cases,
Yeah.
which was the first cases I got involved in. It was a case involving, I think I alluded to it earlier, a challenge to exclusive territories in Coke, Pepsi,
Right.
and the 6 other leading soft drink suppliers at the time. And it was a very interesting case. Gordon Spivak, Willis Snell, and I tried it. And then while that case was awaiting decision, Milton Handler was trying the PepsiCo case. And Professor Handler was sufficiently happy with the record in the Coke case that he proposed to the government that he would stipulate the record in the Coke case as the record in the Pepsi case. So you had basically two identical records as far as all the competition analysis is concerned. And what happened there is Coke and Pepsi won at the trial level. As we said before, as it happens sometimes, they lost at the commission level. Professor Handler appealed to the Second Circuit. Coca-Cola appealed to the D.C. Circuit.
With the same record.
With the same record, and you couldn't consolidate them because they're different cases. And luckily, Congress intervened and said that exclusive territories in the soft drink industry had to be judged under the rule of reason, and those cases were never decided.
Well, let's come back to the section of antitrust law for a moment. Like antitrust law itself, historically, the section has changed over time. What changes come to your mind as being significant?
Well, I think one of the biggest changes is the leadership is a lot larger today, even though the section itself is probably a little smaller. And by having the leadership larger, you get opportunities for more people to get involved in important roles in section activities earlier, and you have more opportunities for advancement. The core of the section, trying to reach out to all groups, to government lawyers, to in-house lawyers, to private plaintiffs' lawyers, to defense lawyers, to have an all-inclusive broad section, I think, is still there. The meritocracy approach is still there. We've made all sorts of efforts over the years to have outreach for minorities and for women and for other groups that weren't as highly represented as we would have liked them to be. All those things, I think, are good, and I think the section, at least as far as I can tell, is in good health and doing well today.
So if you had to do it all over again, would you do it again?
Yes.
Yes. Mike, thank you very much.
Jim, thank you.
Appreciate you being here today.
taking the time.
Very good.